Hi viewers, you are well aware that I am Dr. Jetling Ellosa, running a YouTube channel, named it as a Law Species in English, Nyaya Prasang in Hindi, and Nyaya Prasangalu in Telugu languages. It is a multilingual channel. I am regularly posting my lectures on different facets and aspects of law. And today I am posting my lecture on the top 10 judgments, decisions rendered by the Supreme Court of India in 2025. So, as you know that the Supreme Court of India is the apex court of the land, and it has vested the power to interpret the laws as per the Constitution of India is concerned, and it is a independent body. Since 1950s, its evolution has rendered remarkable and landmark judgments, and till date, from 1950s to 2025, it has handled around 75,000 cases of a voluminous judgments, and still it is a very active. Every year is delivering the very landmark and innovative judgments in a per year. It has delivering around 1100 judgments as average basis is concerned, and it has time and again is interpreting the Constitution of India. As you know that there are three important articles are there, which I repeat here. Article 136 of the Constitution of India, which provides that special leave appeal can be filed against any order of the high courts in the Supreme Court. And we have the another article called Article 141, which provides that whatever law declared by the Supreme Court of India is binds upon all the courts. So it is creating a precedental value that is there in the Article 141. And Article 143 also there, which providing advisory jurisdiction to the Supreme Court of India when the President of India wanted to have the advices, legal advices, then he can write to Supreme Court, and Supreme Court of India time and again has delivering the advisory jurisdictions regarding the question of law as well as the sometimes even for the facts are concerned. So today my lecture basically I am dealing with the top 10 judgments of the Supreme Court in 2025. Here, before going that, but our Supreme Court is playing a very remarkable, active. If we compare the other courts like the United States of America, there the Supreme Court of United States only 73 cases have been argued, and only 53 judgments have been signed. If we go for the United Kingdom, where that country's highest court has delivered only 50 judgments out of 200 cases, which in 2025. But Indian Supreme Court is giving very, very majority judgments, as I told you, that around 1100 judgments per annum. Last time it has delivered 1426 judgments in 2025. So which shows that the activeness on the part of the Supreme Court. Now we go turn to the top 10 judgments of the Supreme Court. For that, the number one judgment is the Gayatri Balaswamy versus ISG Novasoft Technologies, where the court has delivered, the court has a limited power to modify the arbitral awards. So the five judges bench held by 4-1, stating that the courts have possessing a limited power to modify the arbitral awards under section 34 of the Arbitration and the Conciliation Act of 1996 is concerned. So they cannot interfere in the arbitral awards passed by the forums which are there under the Arbitration and Conciliation Act of 1996. So it is, if they interfere, it is a clear transgression of the act. So the Supreme Court has forbidden that the courts have no full power, only it has a limited power to modify the arbitral awards. And second most important judgment is, that is the Padi Kaushik Reddy versus State of Telangana, the two judge bench has occasion to discuss the constitutional immunity of the speaker. So speaker is a constitutional authority. He heads the legislative assembly. Whether he has a unfettered power to declare a person comes under the the 10th schedule for his anti-party activities are crossing to the other party. So we have that act provide whether then the speaker has to give the decision within the time bound manner, or he has unfettered power of delaying the taking the decision. So that was being questioned by the petitioner Padi Kaushik Reddy in this case, and the Supreme Court has stated that the speaker is to follow the constitution, is bound to follow. So the 10th schedule, which provides the defection matters, should be decided within time bound manner. He cannot go on to postpone the matter indefinite periods. So the speaker has been given a kind of a direction that which is earlier it has also given in the Koheto Holahan versus Joseon Liu case in 1997. Same has been repeated by the Supreme Court in this case, and the speaker has to take the decision in a time bound manner, that he is a authority under the constitution, so that he has to take the decision within the time manner. Then this is the third important case law we have to discuss, that is the Anjuman Isaac Talim Trust versus the state of Maharashtra. The two judges bench has interpreted the RTE Act, Right to Education Act, where the Right to Education Act apparently applies to the minority institutions which constituted under the Article 30 of the Constitution of India. The justices, the Deepankar Datta and Manmohan, they have held that the Right to Education Act, where mandating the teachers who not qualified the TET exam has to write the qualify to be continued as a teachers, and in this case the court held that there is a for the, if the teacher is a pertains belongs to the minority institution, he has not to follow the rule of passing the TET examination, because these are the minority institutions. They have enjoy the special privileges. That was the opinion of the Supreme Court. So that is also one of the important landmark judgment rendered by the Supreme Court in 2025. The other fourth judgment I am quoting here in review of Waqt Amendment Act of 2025. So the Waqf Act was amended by the Parliament of India. Then that amendment was challenged in this case. Then the Supreme Court has stated that interim stay can be granted to this act, because the amendment was made by the Supreme Legislature, the Parliament of India, the Chief Justices B.R. Gawai and the Justices A.C. Moshish delivered the judgment stating that there is no mandatory on the part of the court to interfere in this matter to grant the stay for the strict implementation of the Waqf Act is concerned. So the matter is now rest subsidized. Then the fifth important judgment is that the Kalyani Transco versus Bhushan Power and Steel Limited. Here in this case, 3 judges bench has opined the revival, not liquidation of the Bhushan Steel Company, where the JSW company, they wanted to acquire by 19,700 crores, and so for that it has interpreted the Insolvency and the Bankruptcy Code of 2016, popularly called as a IBC code. Then there it has been held that these creditors have limited role in acquiring the firm, and the IRC, the IBC is to be strictly followed by the company while acquiring the Bhushan Steel Company. That acquisition process was been reversed by the Supreme Court in this case. Then sixth important case, the landmark judgment delivered by the Supreme Court in 2025 is the Rajneesh KV versus K Deepu. The 5 judges, they have taken the note of the direct recruitment of the district judges from the bar stream. So the matter is pertains to the to become a direct district judge, one should have the experience of 7 years as an advocate. He has to practice as advocacy, then only he can be get the eligibility to write the judges exam. So in this case, what happened? The the petitioner was got selected for the post of the junior civil judge, the lawyer judge, and he shown that has a experience for the district judge. So the matter went to Supreme Court, and Supreme Court has interpreted the Article 233 of the Constitution of India, where which states that the who can become a district judge directly. So here it is clearly stated in the Article 233 that only he should have the 7 years of advocate practice. And so if a judge is writing, the lower rank judge is writing the exam, so the Supreme Court has held that it does not exclude the candidates who enter judicial service after acquiring the requisite bar experience. The court has accepted that a candidate can show the bar as well as the judicial service experience to become a district judge. The seventh important judgment is that this is a Jane Kaushik versus Union of India. In this two bench just affirm the transgender rights. So this judgment was delivered in October 2025, where the justices Pardiwala and the Mahadevan, they have came out with a landmark judgment giving the special rights to the transgenders. They cannot be denied of the employment basing upon the gender inequalities. Because in way back in 2014 in Nalsa versus Union of India case, the transgenders identification is specially identified, recognition specially identified. So court is noted that no institution should apathetic towards the transgenders. So they should be strictly follow the act, the Transgenders Persons Protection of Rights Act of 2019 and the subsequent rules of 2020. They should not discriminated. They should shown apathy while dealing with the transgenders. Then we have the eighth important case law, that is the Kridai versus Vana Shakti. The three judges bench has occasion to discuss what is meant by legality of ex posto facto law, and it has been decided that in this case that they have to clearly follow the principles which has been enshrined in the ex posto facto law. They cannot violate at any point of time. Then the other important judgment, that is a ninth important topmost judgment of Supreme Court of 2025, that is the Madras Bar Association versus Union of India. The two bench judges had occasion to discuss the striking down key provisions of the Tribunal Reforms Act. So division bench of the justices B.R. Gawai and K.V. Chandran struck down the key provisions of the Tribunals Reforms Act of 2021, where the Parliament has made some amendments to it, stating that it wanted to strengthen the Tribunals Reforms Act. but the Supreme Court has stated that it is nothing but interference in the act, so the Parliament cannot interfere in this matter. Then there is a last 10th important judgment, that is the review assent withholding of reservation of bills by the governor and the president of India. There is another constitutional functionaries that the judgment was delivered by the 5-judge bench, where it has been opened that no timelines for the assent. So the governors and the president of India has a powers under the Article 200 and 201 to give the accent to the bills passed by the parliament and legislative assemblies respectively. Then the question came that whether the governor can retain the bill forever, can keep the bill forever. So that matter was went to by the Tamil Nadu government, and they filed a case in the Supreme Court, and Supreme Court has in an advisory opinion held that the governors should not retain the bill for themselves. They have to follow the constitutional principles, and the court has that it can issue the limited mandamus. It can to a governor if he delays the deciding on the state bill. So they have to either to reject the bill, to send back to the assembly for reconsideration, or to give the assent. So these are some of the 10 most top cases which was reported in the 2025 by the Supreme Court of India. So Supreme Court of India is playing a very, very active role. Though we have the lot of pendency of cases are there, around 91,000 cases have been in pendency cases are there, and there are 69,902 cases have been ready for hearing, but because of the number of factors, the Supreme Court, like the lack of funds, lack of manpower, lack of infrastructure, so all these factors have been resulting into the delay in disposing the cases. But the government should think that getting of a justice is a basic right and also a constitutional right that cannot be denied, and the government, whatever form of government it may be, whatever party it may be, they have to provide the proper infrastructure facilities to the judiciary, so that the independence of judiciary, the growth of judiciary, confidence over the judiciary may going to enhance. So with this, I am concluding my lecture on the top 10 important case laws judgments delivered by the Supreme Court in 2025. Finally, I request all of you, if my lecture is good and knowledgeable, please circulate, share among your communities, and make your valuable comments. Thank you, one and all.